Hello students, greetings of the day. Today we are going to discuss a very interesting topic relating to dowry, that is the Dowry Prohibition Act of 1961. The scheme of discussion is as under. We will start with the introduction, then the main features of the Dowry Prohibition Act, penalties under the Act, then we will discuss the dowry prohibition officers, followed by the case law on dowry prohibition, then a very interesting point that demands that do not fulfill the criteria of demand of dowry, followed by conclusion. Now, let us start with the introduction. The dowry system in India existed prior to the British colonial period. Dowry was not regarded as money or a fee that was the bride's parents were obligated to pay at the time. One of the primary functions of the dowry was to protect the wife against mistreatment at the hands of her husband and his family. Additionally, the dowry assisted the bride and the groom in establishing an existence together following their matrimonial union. Under British colonial governance, women were forbidden from owning any type of property. Women were prohibited from obtaining any type of property, land or assets. As a result, the guys received all of the gifts that the bride's parents had given. The imposition of the dowry system as a compulsory measure during the British Raj placed the bride's family under enormous financial strain. At this time, dowry violence emerged as a prominent feature that continues to be observed. Violence is employed by a groom or his family in order to coerce the bride's family into transferring funds as gift. This system results in post-marriage reliance on the spouses or in-laws for women. Establishing a single method for giving or receiving dowry is practically impossible. This is because the form and nature of dowry frequently fluctuate, making it exceedingly difficult to identify a single method. Therefore, in addition to the typical dowry payments given to the groom and his family, valuables transferred to the spouse or his relatives after the wedding are also considered dowry. One of the determining factors for this classification is that the transaction occurs in connection with the wedding union. It should come as no surprise, but it is reprehensible that a significant amount of violence that aimed at women involves and is concerned with the non-payment of dowry demand from the perpetrator. Torture of the newlywed girl and the bride burning are documented incidents that occurred year after the couple had cohabitated under the institution of marriage. This indicates that the phenomena is not limited to demands made solely during the matrimonial ceremony, but instead continues to exist well beyond the time that the ceremony is solemnized. The legislation related to dowry prohibition, that is the Dowry Prohibition Act, was enacted by the legislature in 1961 as a response to the growing threat posed by dowry. Although the act was the first important step to address the increasing number of dowry cases, its intended goals have been hampered by several legal defects, which have necessitated further measures to tackle the issue. As a consequence of this, the Indian Penal Code 1860 was revised to include Section 304B, which established the crime of dowry death as a different category of crime that carries a maximum sentence of life imprisonment and a minimum sentence of 7 years in jail. Despite the fact that this clause, when construed in conjunction with Section 113B of the Indian Evidence Act, has made it easier to convict a large number of people who had managed to avoid detection under the Dowry Prevention Act. It has also been shown to be insufficient in totally addressing the threat that dowry poses. A new tendency in the judiciary, which may be a reaction to this failure, has been the addition of murder charges under Section 302 of the Indian Penal Code to charges under Section 304B of the same code, which allows for the imposition of death penalty on those who commit the felony. It is difficult to predict whether or not this pattern will continue. Nonetheless, we sincerely hope it will not stick around. However, despite the fact that dowry-related murder is undoubtedly a heinous and a horrifying crime, the continual application of the death penalty to individuals who have been found guilty does not result in justice being served to either of the parties involved. Main features of the Dowry Prohibition Act. The term dowry refers to any valuable security or property that is either directly or indirectly given or committed to be given through one of the spouses in matrimony to the other spouse by an individual, including the parents of one of the spouses to the other spouse or any other individual, prior to, on or before or in regard to the marriage at any point following the ceremony mentioned above, excluding dower or meher for individuals subject to the Islamic personal law Shariat. Further, the term valuable security retains its definition from Section 30 of the Indian Penal Code. The Act also provides for penalties for dowry giving or receiving. Following the enactment of this legislation, any individual who engages in, facilitates or aids in the dowry giving or receiving shall be subject to the following penalties: 6 months imprisonment for a minimum of 7 years, or a fine not less than 15,000 rupees, or the amount of the dowry's value, whichever is greater. Nothing here will have any bearing on or application to the gifts given to the bride during the wedding ceremony that were not requested or solicited. Any agreement pertaining to the payment or receipt of dowry shall be void. Assuming that the donations in question are documented in a manner consistent with the rules set forth by this law, presents given to the bride or groom during the marriage ceremony must be recorded in a list upheld in adherence to the regulations established under the law. Additionally, in cases where such gifts are presented by or on behalf of the bride or a close relative of the bride, they should be traditional in style and not cost more than what is fair given in the bride's representative's financial situation. Penalties under the Act. The Act establishes a penalty for the demand of dowry under Section 14. Anyone found guilty of directly or indirectly requesting dowry from the parents, guardians or other family members of an engaged or the prospective spouse faces a fine of up to 10,000 rupees and a jail term of 6 months to 2 years. Advertisements for soliciting brides or grooms have been prohibited under Section 24 subclause A. If an individual proposes in exchange for the matrimonial union of his son, daughter or other relative any portion of his property, money or both, in the form of an interest in a business or other venture as advertised in a newspaper, periodical, journal or other media, the offender shall be subject to an imprisonment for a minimum of 6 months and a maximum of 5 years and a fine not to exceed 15,000 rupees. For sufficient and exceptional reasons to be noted in the judgment, the court may impose a penitentiary term of not more than 6 months. In the event that a dowry is acquired by an individual other than the woman whose marriage it is associated with, that individual shall transmit the dowry to the woman where the dowry was acquired prior to the matrimonial union within a period of 3 months subsequent to the matrimonial date or within 3 months from the date of receipt, if the dowry was received at the time of or subsequent to matrimonial union, or in the event that the dowry was acquired during the women's minor years, no later than 3 months subsequent to her reaching the age of 18, and shall hold it in trust for the women's benefit pending such transfer. In the event that an individual neglects to execute the transfer of any property as mandated by law within the designated time period, they shall be subject to imprisonment for a minimum of 6 months and a maximum of 2 years or a fine of 5,000 rupees and 10,000 rupees or both. If a woman entitled to a property passes away prior to receiving it, her successors shall have the right to assert a claim for the property from the person currently in possession of it. In the event of a woman's demise other than from natural causes within 7 years of her matrimonial union, said property shall be transferred to her parents in the absence of offspring, or be transferred to the child or children, if any, and be held in trust for them while the transfer is pending. Irrespective of any provisions in the Code of Criminal Procedure 1973, a court shall not adjudicate any offence under this Act in a capacity lower than that of a metropolitan magistrate or a judicial magistrate of first class. In the event that a court determines an offence under this Act, it shall do so only upon information attributable to the police or its own knowledge of the facts constituting the offence, or a formal complaint lodged by the individual harmed by the transgression, their parent or other relative, or an officially recognized welfare institution or organization. Students, any person convicted of an offence pursuant to this Act may have a metropolitan magistrate or a judicial magistrate of first class impose any sentence authorized by this Act. It has been mentioned under Section 8 of the Act that offences are cognizable for specific reasons, bailable and non-compoundable. Certain circumstances involve the onus to prove in cases where an individual is charged with aiding or abetting the taking of dowry in violation of Section 3 or demanding dowry in violation of the law. The onus shall lie on him to prove that he did not act in contravention of the law. Next is the dowry prohibition officers. The number of dowry prohibition officers may be designated by the state government, which may also establish the scope of authority and jurisdiction under this legislation. The following parts and responsibilities shall be exercised and carried out by each dowry prohibition officer: ensuring compliance with the stipulations of this Act to the greatest extent feasible to deter the act of obtaining, aiding or abetting the acquisition of dowry, to gather any evidence deemed essential for the prosecution of individuals found guilty of violating the provisions of the Act, and to carry out any supplementary duties that the state government may delegate to him or that are specified in the regulations promulgated pursuant to this Act. Next, by means of official notification in the Gazette, the state government may grant the dowry prohibition the authority of a police officer as specified in the notification. The officer shall exercise said authority in accordance with the regulations established under this Act, subject to such limitations and conditions. Next duty is to provide guidance and support to dowry prohibition officers as they carry out their duties under this Act effectively. The state government may establish an advisory board of a maximum of 5 social welfare workers, with the minimum of 2 being women from the jurisdiction of the dowry prohibition officer. The central government may establish regulations for carrying out the purposes of this Act. These regulations may specifically and without limiting the applicability of the aforementioned authority stipulate all matters pertaining to the maintenance of a list of presents as specified in 3, including the structure, method and individuals responsible for its upkeep and the improvement of policy and action coordination in the implementation of this legislation. Each rule formulated under this section must be laid out in each House of Parliament in a timely manner during its 30-day session. This session can be completed in one session or in 3 consecutive sessions. If both houses agree to amend the rule, or if they agree it should stay unchanged, they must lay the rules before the houses. Now we will discuss case law on dowry prohibition. In Bachni Devi and another versus State of Haryana through Secretary Home Department 2011, Supreme Court held that the appellant's request for a motorcycle to be utilized in the second appellant's business constituted a demand for dowry. The court deemed it crucial when resolving this case that the suicidal victim had endured harassment and mistreatment subsequent to the unfulfilled demand for the motorcycle. With reference to the dowry regulations, the 3-judge bench consisting of Chief Justice T.S. Thakur, Dr. A.K. Sikri and R. Bhanumati stated in the matter of Bobili Ramakrishna Raju Yadav versus State of Andhra Pradesh 2016 that the presentation of dowry and traditional gifts during or near the wedding does not create any interference, that the property was entrusted to or placed under the control of bride's in-laws or other close relatives with the intention of exploiting the provision of Section 6 of the Dowry Prohibition Act. While interpreting the Section 6 of the Dowry Prohibition Act, Supreme Court stated that if the dowry is received by an individual other than the bride, that person is obligated to transfer it to the woman whose marriage it is intended for in connection with the marriage. Failure to do so within 3 months from the date of marriage shall result in a penalty for violating Section 6 of the Dowry Prohibition Act. Additionally, the court determined that in event that the dowry amount or articles of a married woman were entrusted to care of her husband or in-laws, they would be considered trustees of the same. In accordance with Section 6 of the Dowry Prohibition Act, the individual who receives dowry articles or has authority over them must return them to the women for whose matrimonial union they were intended within 3 months of the intended date of wedding. He will be culpable of a dowry offence under the aforementioned section if he fails to comply. Furthermore, it was determined that he is obligated to return the dowry to the women within the time frame specified in the order, notwithstanding his conviction. In a number of additional cases, the nature of gifts, property and money that when demanded comprise dowry demands has been established. Moreover, in the case of Ashok Kumar versus State of Haryana 2010, the Supreme Court affirmed that a husband's torture and harassment of his wife in response to his father-in-law's refusal to pay a specific quantity will constitute a dowry demand. In the matter of Arun versus State of UP 2020, Arun and his family visited Jyoti's residence to finalize the marriage proposal. The ring ceremony was conducted on July 21, 2013 and the wedding was arranged for November 19, 2013. Subsequently, Arun began to pay frequent visits to Jyoti's residence where he deceived her into believing that with the matrimonial union finalized and only Fera's ceremony remaining, he would accompany her on numerous excursions. By coercing Jyoti into his room, he proceeded to initiate a physical relationship with her. However, the appellant subsequently began to demand a dowry of 5 lakh rupees. Regarding this, Mahila Thana was presented with a complaint, but no action was taken. Upon learning that Arun's marriage had been arranged with another woman in exchange of a substantial dowry, the first information report was formally filed. Upon examination of the aforementioned facts, the court held that it becomes evident that the fundamental components of the offence stipulated in section 3 and 4 of the Dowry Prohibition Act have been met in this case. The aforementioned allegations from FIR unequivocally demonstrate that Arun demanded a dowry of rupees 5 lakh from the complainants. Therefore, it is not possible to assert that appellants have not committed an offence under the Dowry Prohibition Act. Due to the fact that the first information report contains direct allegation of dowry demand, the charges brought against the appellants under section 3 and 4 of the aforementioned Act are not subject to question. Students, now we will discuss the demands that do not fulfill the criteria of demand for dowry. In Anil Kumar Gupta versus State of UP 2011, demands for gifts or money after the birth of a male child were not considered as a demand for dowry. Moreover, in Appa Sahib and another versus State of Maharashtra 2007, the court determined that the appellant's request of funds could not be classified as dowry demands because they were driven by financial constraints and the necessity to fulfill urgent domestic obligations. The court obiter grief stated in Baldev Singh versus State of Punjab 2008 that a husband's request for a portion of victim's ancestral property did not fall in the category of a dowry demand. Now, let us discuss the conclusion. The exercise of dowry is widespread and transcends all disparities based on financial status, religious affiliation and caste in India. The delegation of control over one's daughter is regarded as a religious obligation for the father. With the inference of this dharma that the groom's family bestows money and other advantages upon close relatives' marriage partners and his family in the majority of the cases. The enormity of this request is beyond the financial resources that a woman's family possesses, which results in the accumulation of massive responsibility to satisfy this religious commitment. Due to the fact that this custom is so deeply rooted in the framework of society, it is frequently regarded as a commonplace social event. With this, we come to an end of today's lecture. Thank you so much for the patience listening.